Mr. Patel walked into Congress already carrying the weight of his own words. Before he became the nation's top law enforcement official, he spoke boldly about Jeffrey Epstein's files, calling them the ultimate test of transparency. Back then, he told interviewers that the infamous Black Book was under the direct control of the FBI director. He went on podcasts and television saying that if he ever had the authority, the public would finally see the names inside. He told audiences that no stone would be left unturned, no documents hidden, no cover-ups tolerated. Those words were repeated again and again, tweets in early 2025, sound bites in June interviews, promises that survivors and the public clung to. And yet, just weeks later, a different message emerged.
And said that there was nothing more to see. Your July memo says you uncovered more than 300 gigabytes of data and physical evidence, but that you had decided no further disclosure would be appropriate or warranted. That is a quote. I think what happened, Mr. Patel, is that suddenly you discovered that Donald Trump's name was all over these files, and you started a giant cover-up. So you are under oath, Mr. Patel. You just testified to Mr. Swalwell that you did not speak to the president about the Epstein files. To your knowledge, did Attorney General Pam Bondi speak to the president about what was in the Epstein files?
I can't speak for Attorney General Pam Bondi.
So to your knowledge, you don't have any information. The question was, do you have any knowledge? Do you have any knowledge?
I can't speak.
You are refusing to answer the question, so let me tell you that the Wall Street Journal reported that in May, Bondi told Trump that he was in the Epstein files, and at the same meeting said that the DOJ did not plan to release the files. Yesterday, you testified to Senator Kennedy that there was, quote, no credible information that Epstein trafficked girls to anyone else, and that you have, quote, continuously and publicly asked the public to come forward with more information, and we'll look into it. Today, in response to Mr. Massey's question, you appear to say that the survivors were not credible. These are survivors.
That's not at all what I said.
Okay, great. I'm going to ask you this in a second, but let me tell you about the survivors, and let's bring them up here into the room. These are women who came to the Hill and testified that they were groomed and raped at the age of 14 and 16 years old, and they called to meet with the president and to meet with the FBI and to have people investigate their claims. Some of them have never testified before. If you are so interested in getting the public to submit any information, why have you not met with them? You said you haven't met with them. Have you met with them? I'll give you one more chance.
My job as the FBI director is to invite
all investigative leads. Is the answer yes or no to whether or not you met with these women who were sexually abused and raped?
Any insinuation by you or any people on your side that I am not manhunting child predators and sex traffickers, just look at the stats.
Patel,
and you talk about cover-ups, man.
Mr. Chairman,
you talk about cover-ups.
And I will take as much time as I
Where
want.
were you during the Obama and Biden administrations when these so-called cover-ups were going on? Why didn't anyone in those administrations talk to any of these purported witnesses?
I have some regular order,
every single person to provide credible information.
Time belongs to the gentlelady from Washington.
And I'm going to take another couple of minutes.
When you accuse the witness of something, he's allowed to respond. That's how it works.
Listen, he didn't even, excuse me, Mr. Chairman, you have always been fair. But this is not fair.
And you will get
no, this is my time, and he said that the witnesses were not credible.
Seconds of time.
I'm going to get an additional minute of time because that's how much time he took.
You won't get a minute. You'll get some seconds. What we think is under 5 minutes. You don't get to demand how much time you get. That's not how it works.
Mr. Patel, are the victims of the Jeffrey Epstein horrific trafficking ring, are they credible?
Any person with information about ongoing sexual trafficking.
I'm asking you if they're credible.
Ma'am, I'm commenting on the evidence we have. We have routinely asked for people to come forward with more evidence, and we will look at it. And the evidence that we have was the same evidence that the Biden and Obama Justice Departments had. And they determined, not me, they determined that that information was not credible.
Mr. Chairman, he's not letting me even ask my questions.
You ask the
ridiculous.
questions, he gives an answer. You may not like what he says,
No,
but that doesn't mean you get to interrupt
He's not answering
him.
my question.
Mr.
You
Chairman,
have
could we
an-
restore the gentlelady 45 seconds so she
We
can
will
complete
give her
her question?
additional 30 seconds, which is what I said
I'm
earlier.
going to keep taking my time because
you'll take
here's
the
the
time
thing.
that you get. You get
are
30
not
seconds.
answering the question. The question
I
is,
have. You just don't like the answer.
Are these women credible? It's a yes or no answer.
I have answered the question.
Well,
and
what
I
is
keep
the
telling
answer?
you, I'm the only FBI director that has welcomed new information in this
Okay.
case. This
You're
administration is the only one that has welcomed any new information in this
Is there
case.
a yes or no to whether
Present
the
new credible
victims are
information.
credible?
Present new
Are
information.
the victims credible
The victims-
or not?
I'll tell you what happened in the last Trump
Are they
administration.
credible or not? You can't even
Victims
say.
credibly came forward, and you know what happened? President Trump authorized the indictments
President
of Jeffrey
Trump
Epstein,
called
not
them a
Biden,
hoax.
not Obama,
President Trump
no one
called
else.
the entire thing a Democratic hoax. So I would like to ask
The
you
gentlelady's
if
time has
you
expired.
will
I gave her the
meet-
additional
if
45
you-
seconds she
if you
requested.
will
The
meet-
gentlelady yields back. The gentleman from
Mr.
New
Chairman,
Jersey is
I would like
recognized
to
for his
ask if
5
you would
minutes.
meet with the women who were sexually
time does not belong-
abused and raped and
time
groomed
does
at
not
the
belong
ages
to the
of
gentlelady from
14
Washington.
and
The time now
16
belongs-
years old. Are
the
you
time-
going to cover up?
No, I'm
Are
not
you
gonna-
going to
I'm
continue
gonna
to
recognize
cover
the
up
gentleman
for
from
the
New Jersey
rich
for
and
his 5 minutes.
powerful men, including those that might be on this committee?
I can yell
Or
too,
are
Mr.
you
Chairman,
going
but I don't wanna
to
yell
allow
above
them
this.
to
The time belongs
testify?
to the gentleman from New Jersey. I
Are you
appreciate the
going to allow
gentlelady
them to
yielding
testify,
back.
Mr. Patel?
Go ahead.
Will
Mr.
you
Angelo.
allow them to testify to you, Mr. Patel?
Mr. Patel, thank you for being here. I know it's been an interesting and difficult 2 days. And I wasn't going to talk about the Epstein thing because there's a lot of other issues that affect the FBI, but I have to say a few words. I've sat
In July, a memo surfaced confirming more than 300 gigabytes of data and physical evidence existed, but the decision had been made that no further disclosure was appropriate or warranted. That abrupt shift sparked outrage, suspicion, and the confrontation that would unfold in a packed hearing room. For Representative Pramila Jayapal, the contrast was more than political rhetoric. She saw broken promises. She saw a man who once demanded transparency now leaning on legal shields to avoid uncomfortable truths. And she made it clear she believed the reversal had less to do with legal restrictions and more to do with names. According to press reports in May, Attorney General Pam Bondi privately told the president that his name appeared in the Epstein files and that at the same meeting the Department of Justice decided against releasing them. If that report was accurate, the timing was damning. Patel's July memo, released just weeks later, declared the evidence too sensitive to share. To Jayapal and to millions watching, it looked like a convenient retreat into secrecy. But this wasn't just about documents and memos. Survivors of Epstein's trafficking ring had come forward, some for the first time, with stories of being groomed and abused as young teenagers. At 14 and 16, they said their lives had been stolen, their voices silenced, and now, decades later, they demanded not only accountability but recognition. They asked to meet with the FBI director. They asked to meet with the president. They asked to be heard by people in power who had once promised justice, and yet Patel admitted he had not met with them. He insisted his role was to pursue predators and follow evidence, but when pressed for a simple yes or no on whether he believed these women were credible, he refused to give one. Instead, they spoke of legal standards, prior administrations, and the technicalities of evidence. Jayapal's voice grew sharper. Survivors were not asking for legal jargon, they were asking for humanity. That clash played out in real time. Jayapal asked again and again, "Are the victims credible?" Patel answered with phrases about any person with credible information and about how evidence was reviewed by past Justice departments. He would not say yes and he would not say no. The tension in the room was palpable. Members interjected, time clocks beeped, arguments about procedure broke out, but the central question lingered unanswered. Were the women who had testified about being groomed and abused as teenagers credible? For survivors watching, the refusal to answer felt like dismissal. For Patel, perhaps it was the fear that any statement could have legal repercussions, but to the public it sounded evasive. Patel did have a defense, and he made sure to repeat it. He said the FBI had released everything it could lawfully release. He cited sealed grand jury materials, court orders designed to protect investigations, limited warrants from earlier probes that constrained what evidence was ever collected, and decades-old non-prosecution agreements that tied the hands of investigators today. He argued that unless a court unseals those materials, the FBI director cannot simply dump them into the public domain. On paper, those legal explanations may have been correct, but politically and morally they rang hollow, because the real question was not just whether the FBI had complied with existing restrictions, it was whether Patel had fought to lift them. If he once told the public that the Black Book could be released at the discretion of the director, then what changed? Did he file motions to unseal records? Did he direct government lawyers to push for expanded disclosure? Did he pursue every lawful avenue to honor the promises he had made before taking office? Or did he accept the constraints as convenient cover, retreating into the safety of procedure once the political costs grew too high? Those were the questions Jayapal was raising, and they mattered not only to Congress but to every viewer trying to understand whether words of transparency meant anything at all. The credibility gap widened with every exchange. On one side, a congresswoman demanding moral clarity: survivors deserve to be called credible, and the public deserves to know if names are being protected. On the other, a director citing legalistic limits, avoiding direct answers, and framing survivors' stories in terms of evidence not deemed credible by past administrations. That careful phrasing may have been meant as neutral, but it landed as cold. Survivors rarely seek legal validation, they seek recognition, they seek to be believed. And when the head of the FBI sidesteps a yes or no, it fuels suspicion that powerful men are being shielded. The July memo itself raised further suspicion. It referenced more than 300 gigabytes of data and physical evidence, a massive trove by any standard, and yet concluded disclosure was neither appropriate nor warranted. What exactly did that data contain? Were those files simply duplicates of what had already been reviewed in prior investigations, or was there material that had never been made public? Without transparency, the public is left to speculate, and speculation once unleashed spreads faster than facts. That's why survivors and representatives alike demanded more than generic assurances. They wanted proof that the system was not protecting the powerful at the expense of the vulnerable. In fairness, Patel's position reflects a recurring tension in law enforcement, the clash between legal process and moral expectation. Courts do impose restrictions. Grand jury material is tightly protected. Search warrants limit what evidence can be seized. Non-prosecution agreements, however controversial, can prevent investigators from reopening certain lines of inquiry. From a lawyer's perspective, Patel's words may have been accurate, but from the standpoint of survivors and the public, accuracy is not enough. They wanted effort. They wanted to see that the director who once said everything should be released had at least tried everything in his power to make it happen. Filing motions, petitioning courts, litigating to unseal, those are the steps that demonstrate commitment. Without them, legal accuracy looks like excuse-making. And so the confrontation in that hearing room became more than another political skirmish. It became a test of credibility not only for Patel but for institutions themselves. When promises are made in public, especially to victims of horrific crimes, breaking them carries consequences. Trust in the FBI has already eroded through years of controversy. This clash threatened to deepen that divide. Survivors and their advocates see a pattern of silence, secrecy, and technical excuses. Officials see themselves bound by rules, fearful that one misstep could jeopardize prosecutions or violate judicial orders. Both perspectives exist, but when placed side by side, the human one feels heavier. So where does this leave Congress, the public, and the survivors themselves? Oversight bodies do have options. They can issue subpoenas for specific documents. They can seek in-camera judicial review, asking judges to privately examine sealed materials and determine whether public interest outweighs confidentiality. They can compel testimony from officials about what steps were actually taken to unseal records. Was there litigation? Were motions filed? Did anyone inside the FBI push for transparency in court? Those are factual questions Congress can pursue. Beyond Congress, independent reviews can be launched, inspectors general or special counsels tasked with auditing whether the full authority of the FBI and DOJ was exercised to fight for disclosure. Survivors too have legal pathways. Victim advocates and attorneys can petition for protective hearings, where testimony and evidence are heard in settings that preserve privacy while still creating a public record. They can seek redacted disclosures, balancing transparency with safety. The key is that survivors should not be left to shout into the void, forever told that the evidence is not credible without ever being allowed to show why it is. If Patel truly means that he welcomes new information, then meeting survivors, listening to them directly, and ensuring their claims are fully documented should be the baseline. The public has a role as well. Citizens can press representatives to demand the litigation record. Was disclosure opposed? On what legal grounds? Who filed the motions and what appeals were taken? Transparency about the fight for transparency may sound ironic, but it is necessary. People need to see that every avenue was exhausted. Without that proof, promises of openness collapse into political theater. At its core, this confrontation highlights a bigger question: what does it mean to keep a promise of transparency? Does it mean complying with existing rules and stopping there? Or does it mean pushing those rules to their limits, fighting in court, appealing decisions, exhausting every lawful option until no stone is truly left unturned? Survivors believe the latter. Patel so far has delivered only the former, and that is why the clash with Jayapal felt so raw. It wasn't just about documents, it was about whether institutions stand with survivors or hide behind procedure. As the hearing wrapped up, tempers still hot, time still contested, the larger issue remained unresolved. Survivors are still waiting, Congress is still asking, the FBI is still citing legal constraints, and the public is left wondering whether the system is designed to protect the powerful rather than the vulnerable. The answer to that question won't come in a single hearing. It will come in whether motions are filed, whether survivors are met with respect, and whether the next headline says records were unsealed because leaders fought for them. That's why this moment matters far beyond Washington. It's not only about one director or one set of files, it's about trust. Institutions endure only if the public believes leaders fight for them, especially the most vulnerable among them. When survivors testify about abuse at 14 and 16, the very least they deserve is acknowledgement. When officials promise transparency, the very least they owe is effort. Anything less deepens cynicism and fuels suspicion. Anything less tells survivors their pain is negotiable. Jayapal's confrontation was more than a shouting match. It was a mirror held up to the promises of power. Promises made on podcasts and stages are easy. Promises kept in the face of legal barriers, political costs and powerful names, that is where credibility is won or lost. And now Patel faces the test he set for himself. Will he fight or will he hide behind procedure? That is the question survivors, lawmakers and citizens will keep asking. So what do you think? Has Patel done enough to unseal the Epstein records? What would convince you that he tried everything lawful to deliver full transparency? Let us know in the comments, and don't forget to subscribe and hit the bell, because these aren't just hearings. They're accountability tests for the very institutions meant to serve us, and the answers we demand now will shape whether justice is ever truly seen.